Hey folks, welcome back to the Edupedia world, and I am Abhinay Gupta. And today again we are continuing with the interpretation of statutes, deeds and documents, right? And so far we have completed all the primary rules of interpretation. We are done with the secondary rules of interpretation, and we are also done with the internal aid to interpretation. So any one of you, if you have missed out in any of these major topics, please go back and refer to the previous lectures, right? And in the order in which I have said, we have had classes accordingly, right? So for today, what are we going to do? What is it that is remaining in this chapter, right? So if I remind you, then we still have two things to do in this entire chapter, which is the external aid to interpretation and the interpretation of deeds and documents. Because so far we have only been talking about the interpretation of statute, right? So interpretation of deeds and document is just one topic, and that is the last topic, a very small topic, right, in this chapter. And after that we will be done with this chapter, right? And if needed, we would go with some of the questions from the practice manual, right? So let us begin with the chapter today. So what we do is the external aid to interpretation of statute. This is what will be the main subject matter of the class today. So if we look at the external aids to interpretation that we have, then here is the list. First, the historical setting is to be seen. Earlier and later acts and the analogous acts that have been enacted has also to be referred. The usage, the reference to other acts, dictionary definition, and the judicial pronouncements. Now there is one thing that you need to very clearly understand and identify, right? That the topics given in your study material as per your institute is a little different than the topics that are a part of the interpretation of statute as an external aid, and the topics that are also referred by the other authors, right? Because if you refer to the literal, to the real interpretation of statute, if you refer to the rules over there, if you refer to the external aid, you can directly Google it, right? And you get the points over there, right? Which are a little different and are a little deviated from the exact points which are given by the institute, right? So basically now it is a challenge for you, or the question for us, as to what are the actual interpretational aids that we follow. Or instead the correct question would be, what are the actual interpretational aids that we should write in our examination, right? So basically this is a question. Now when we talk about the interpretation of statute, right, you can never be sure that the institute will ask you the questions exactly from the study material, right? So the direction that we follow for our preparation for the examination would be a little different, right? We will try to cover both of them. Yeah, don't worry, it will not make it a little lengthy, but the only point is we'll have to play a little smart on that end, right? Now if the institute gives you a question in the examination as to point out the external aid to the interpretation of statute, right, then I will give you a different list that you have to mug up, right? Remember those lists and only write down about those lists. We'll also talk up 2 lines about those lists at the end, right? But if I'm giving you this list is a little different than the list given by the institute, except the word usage that I have inserted, right? If you follow other authors, if you just Google the interpretation of statute, you get something different, and your institute has provided you with something really different. But if you are asked about the historical setting, if you are asked about the dictionary definition, if you are asked about the judicial pronouncements and stuff, then we would try to pick up the content over here. Why? Because if you refer to the institute study material, you do not get a lot of content about those topics, right? So I'll take you with the bullet points, with what are the things that you need to remember, right, and what are the things that you need to write in the examination. But if you get a wholesome question, right, and the question asks you to mention the external aids of interpretation, then you are not supposed to write these 6 points in this way, right? At the end of the external aid of interpretation, I'll again show you one more slide and I'll give you the exact bullet points that are given or that are referred in your institute study material, right? To be on the safer side. Why? Because when you know that the answer that you attempt, your paper goes to be checked, and the examiner who is checking your paper, he has another set of solved answers in front of him that is provided to him by the institute, right? Now, for solving those answers or to give the answers to the question, the institute will not follow some other sources. It will have to be the institute study material, and if the points do not match, you lose your marks over there, right? So to play a little smart on that end, what we will do is that if we have that kind of a question, we will write about those topics and we'll just explain it in 2 lines. Okay, and for that 2 line, I'll give you the summary of the institute study materials content. But otherwise, if you are asked about any topic in detail, then you will have to refer to the discussion that we hold in the class, right? Because this discussion, when I bring out the content for you, basically what I try is to incorporate your institute study material and as well as follow the other authors in the market, reputed authors, right? Because the reputed authors over there, they also give you the correct content, but they give it to you from the bare act. They do not give it to you from the institute study material. But that will not solve our purpose. What we need is that we need to write answers as per the institute study material, and hence I try and make an attempt to collaborate both of them and give you a wholesome knowledge, so that if you are asked questions beyond the study material, you're also prepared for that. And when you are asked questions that are direct, right, that are from the study material, then make sure that you write the points from the study material, right? So I'll keep reminding you and bifurcating the knowledge that I'm providing you into the knowledge that you should be using in the examination if you are asked certain kind of question. But if you are asked to explain something, you will have to use your knowledge that I am giving beyond your study material. I hope you do not have a problem with that, right? So we'll start with the discussion of these individual topics, and obviously we will pick up the very first topic, that is the historical settings, right? And the 4 bullet points that you need to remember for the historical settings are on your screen. 1, you'll have to talk about the parliamentary history, you'll have to talk about the historical facts, you'll have to talk about the statement of objects and reasons, and finally the report of expert committee. So these are the 4 elements that you will be talking about when we talk about the historical settings. And always remember that we are talking about the external aid to interpretation, an aid that is beyond the text of your statute, right? It is not in those documents, it is not in the bare act. We have already seen the internal aid to interpretation, that is the content of the internal aid of interpretation is provided in your statute itself. But these external aids that we will be discussing are beyond your statute, but something that is surrounding the environment of the statute, right? So let us see each of the points in detail, starting with the parliamentary history. So folks, when we are talking about the parliamentary history, right, you need to understand what we exactly mean. So by the parliamentary history, we are not concerned with the history of the parliament. How was it created? How is it enacted? What are the bodies? Who are the members and stuff? No, that is not the purpose. The purpose is to find out what history does this statute have in the parliament. And when we talk about history, we're talking about something that was past. That means we're talking about the situation or the scenario that existed before the act came into force, before the enactment of the act. There is a defined procedure that is followed in your parliament, right, that gives rise or that gives birth to a statute. So we are talking about that procedure. We are talking about the birth of the statutes. So that is the meaning of the parliamentary history, right? So you all know that, okay, the legislature in our country is the parliament. So any act, any law that is enacted, it has to be passed in the parliament, right? So we will be dealing with the process by which the act is enacted. So whenever you need to bring out an act, first thing you need to have is a cause. that leads you to that act. Then the conception of an idea about how are you dealing with that situation. Whatever is there in your mind, right? You have you conceive an idea that yeah, this is the kind of act that needs to be passed. Then what do? Based on your conception, based on your thought process, you will define a bill that this is the problem faced in the country, and to sort it out or to customize it, right, or to make it even more cultured or systemized, what we need to do is we need to pass an act that would be governing that specific provision, or that will be governing that specific subject, right? And then when you have drafted the bill, you bring it into the two houses of the parliament where you have the debate on it, right? You will put forward the counter questions that you need to answer, right? You'll have to have the entire content of the bill. You will have to be for the bill. Other parties will be against the bill. And then you have a debate, and you'll have to satisfy the two houses that yes, your bill is worth, right? And then if there is any amendment to the bill, that they accept that okay, we will be taking forward your bill but subject to certain amendments, then you also incorporate those amendments into the bill and take it forward, right? And then it goes to the parliament, and when it gets approved, it becomes an act. So whenever we are talking about the parliamentary history, right, so this is the parliamentary history of the statute. And the point is, what helps you in interpretation? Because we are basically talking about the external aid of interpretation of the statute. So what in the entire scenario that we have seen in the parliamentary history is actually helping you out to interpret any particular portion of the statute? What is it exactly? So understand one thing, when the bill was actually introduced in the two houses of the parliament, right, somebody must have introduced it, somebody must have come, somebody must have given the bill, and somebody also must have given a background that relates to the bill, right? That yes, my bill has this content, and we are planning to target this issue and to eradicate the issue, right? So there would be a mover of the bill, and he would be giving a speech at the time of the introduction of the bill. And that speech, the content of that speech is relevant for us, for the interpretation of the statute. Why? Because that will exactly give us the intention of the legislature if the bill is actually passed, right? It helps us to ascertain the object and the purpose of the act. Why is certain bill coming up, and why has that bill again been passed, and why has it been converted into an act? Because there was a need. So what is that need? Right? So that is how you get an understanding, that is how you get an interpretation from the exact origination, right? You follow the trails, you track them down, and then you come to a conclusion where you understand the intent of the legislature. So now when the mover has given his speech, right, you have seen the content over there, and then the opponents, they oppose to it, right? There is a debate held. So you will have to also put up or take up the points of the debate, right? What was concluded. And finally, when the bill was passed, it was passed with certain amendments. So what are the content of that amendment? Why did those amendments come up, right? You also need to know that, because that will help you to actually understand that what purpose is it achieving, right? Earlier you know that okay, this is the object, this is the purpose for which it is coming up. But then you also have to see whether that purpose will be solved with this statute. If yes, then you finally come to understand that yes, the statute is useful and it would be interpreted in that specific context. Getting the point? But again, so that you're not confused, you have to pay attention to one more point. That you have nothing to do with the paper which was placed before the cabinet for the introduction of the bill. Why? Because that is not the final paper that was placed in front of the parliament. So why did the cabinet come up with the bill is not important, but why did the parliament actually enact that bill, convert the bill into an act is important. Because that will actually demonstrate the intention of the parliament, which would be actually a little different than the intention of the cabinet who approved the introduction of the bill, right? Because they did not go to that larger extent, they did not go to see the wider picture, which the parliament did, right? So that was about the parliamentary history. Now if we move on to the historical facts, then what are the historical facts that you can use as the external aid to interpretation? So basically when we talk about the historical fact, right, we are trying to refer to the situation that gave rise to the purpose, or that gave rise to the need of the enactment of the statute. Right? There was some event that took place because of which we had to come up with such an act, right? So if we are trying to understand the subject matter and the scope of the enactment, right, then the external circumstances that actually did lead to the enactment of such a statute would actually be a matter of significance, right? And then we also need to consider what effect did the statute have on the previous law. Did it change it? Did it amend it? Or did it let it be the way it was? Right? If it has changed it, then you know the intention and the purpose of changing, and that becomes your new intention or purpose of that act. But if you take it forward, then that means again that there is a situation that you need to tighten your statute. Right? So they give you relevant information as to what has happened and why did it happen, and then so that you are prepared for the next step. Right? Then we have the statement of object and reasons. So basically, do you know what is a statement of object and reason? So whenever anybody is trying to pass a bill, right, when the mover of the bill, he will have to include along with the bill a statement, and that statement will contain the object of the bill and the reason why that bill needs to be passed as an act. Right? He has to give a brief about that okay, this is the object that we are trying to meet, and this is the background reason that we have found out because of which we think that this act should be coming up. Right? Because of that we have come up with this object to achieve, and for that object we are having this bill, and we need this bill to be passed. So that statement of object and reason will give you a brief as to what is the intention behind the enactment of such act, or actually behind the passing of that bill. Why do I say it is not behind the enactment of the act, but it is the reason behind passing of the bill or intention behind passing of the bill? Because when the bill is proposed in the parliament, right, as I told you, they hold a debate, and then there are amendments, there are considerations for that. So after that, if there are a lot of amendments and a lot of considerations to that bill, then it comes out, or it emerges out as an altered bill, and the content or the intention behind that altered bill, that altered act may not be similar to the object of the bill. They may have come up with an entirely different object now. So in that situation it becomes risky for you to depend on that statement, to depend on the statement of object and reason. That could be fatal if it was changed, if amendments had been taken place, and if there is a changed constitution. Right? But if everything remains same and the bill is adopted as it was, then we can rely on the statement of object and reason as well. And the last point that we have to refer in the historical setting is the report of the expert committee. Now, do you understand the meaning of the report of external committee or expert committee? Or do you know who the expert committee is basically? The expert committee basically is, as the name says, a committee of expert. But expert in which field? These are those experts who would be examining the bill that has been proposed by the mover. Right? They will get into the details and they will analyze the entire bill. Right? The intent behind the bill, the object of the bill, the purpose that the bill can achieve, and whether or not the bill is sufficient enough to achieve that purpose, or whether are there any amendments to be made to the said bill to help it to achieve the purpose. Right? So those experts, they will examine the entire bill and then forward their report to the legislature. and they'll say that okay, this bill has this content, this bill does not have this content, that means it lags on this front, right? But this portion will be enough to sort out this problem, but this portion may not be significant or sufficient enough to sort out the other problem, right? All the entire analysis about that bill to the legislature is given by a committee of experts, right? And then the legislature goes ahead to decide that the bill, if it needs to be enacted, then it would be enacted with certain modification, and that modification would be done according to those committee of experts, right? So the report that the expert committee gives to the legislature, right, even that report is important, because that report will very well demonstrate the intent and the scope of the bill. What is the intention, what is the purpose for which the bill is going to be enacted, right? So although there will be a change in the bill as per the amendment and stuff, but for you, your problem is solved, or your conclusion is reached when you understand the exact purpose, because that will help you to interpret the statute. When you know the direction, you can walk as fast as you can, right? Then the rest depends upon your ability, but the external forces or the external impact will now be minimized. Clear? So when we talk about the historical settings, there are basically 4 points. One is the parliamentary history, the entire process of the passing of the bill. Second is the historical fact that led to the birth of this bill, and then an act. The statement of object and reason which is attached to the bill which has been proposed, and the report of the expert on that particular bill to the legislature. Right? Now are you clear with the historical setting? Will you forget it? No. You will always remember it. Right? So if you are okay with this topic, we move on to the next topic. So the next topic that we take up after this would be the earlier and later act and analogous act. So when we talk about the earlier and later act, right, that means we are talking about the current act and the act that prevailed prior to this act, right? And when any old act is replaced by the new act, right, then the previous act would be used to interpret the new act, or to say the new act would be used to interpret the earlier act only if they are on the same tangent, and the text of the previous act, that means the earlier act was ambiguous. That means it was not very clear, right? But if you had any act after that, then that could be referred only if they are on the same line and the same tangent, right? Now when we talk about the earlier acts, right, or the acts that are old, I would also include that into the same context, right? Because if you talk about the content or the heading that is used by the different authors, then that would be change in technology and social conditions, right? Even that would form part of the same thing, but since I'm explaining it to you over here is the reason because we are talking about the older acts, right? So you'll have a mention or the reference to the same over here. So you need to interpret in accordance with the change in situation since the enactment, right? That means if an act was enacted long back and there were certain conditions that, or there are certain conditions related to the same task which are applicable today, right? But at the time when the act was enacted, they had no idea about the applicability of certain things, or they had no idea that in future certain things would come up, right? For that, if I take an example, then there was an act which was enacted in the 19th century, right? That is exactly 1872, which was the Indian Evidence Act. So in that act, they used the word handwritten, right? Handwriting. So when we talk about the handwriting, at that point of time, it was something that has to be written in ink by the hand, right? But later on it was construed to include the typewriting along with handwriting. That means again something written in ink, but not directly with hand, but indirectly with hand by typing the letters, right? You're not writing in the same handwriting, but you are writing in a standard font by typing or pressing the keys on the typewriter, right? But the fact is that the typewriter came into existence after 1872 or after the Indian Evidence Act was enacted. So when the act was enacted, they had written or they had used the word handwriting, because every legal document at that point of time used to be handwritten, right? Because they could not print it or they could not typewrite it, because there was no such concept over there. But later on, with the invention of the typewriter, right, they started using the typewriter. Now if you go out to any court, right, if you get an affidavit over there, if you get any deed registered, then what they do is they take the stamp paper and type it. So there's a typist always there in front of the court. Whenever you want an affidavit, you take the stamp paper, you give it to the typist, tell him the content, and he starts typing it, right? So that concept is still being followed. So the only intention of taking this example was to let you know that if there is any social change, any technological change that has taken place since the enactment of the act, then that would be construed to be a part of the act, right? We would consider or we would interpret the act according to the new inventions, or according to the technological change, or according to the social change, right? We'll keep it at par with the changes, so that the act is not outdated and is not outcasted, right? That is the concept when we talk about the earlier and the later act and the analogous act. So I think we'll keep it to that extent for this lecture, and the rest of the external aid to your interpretation will be taken up in the next lecture, right? We don't have a lot of it remaining, right? I think we have discussed 2, we have 4, but as I've already given you the brief and we have covered the most lengthy one, that was the historical aspect. So we will not take a lot of time and complete all the 4 of them in the next lecture itself, right? So until then, this is Abhinay Gupta signing off. Please stay tuned. Complete with this, refer to some questions in your practice manual and other places, and then come back for the next lecture. And always remember that in the next lecture, at the end, if I forget, you have to remind me with a comment below that I had to give you the list of the content that is given in your study material, right? And we'll discuss them in 2 lines in brief, right? So please stay tuned for that. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.